Here's how to tell whether you need to make an administrative or legislative decision. I'm Jacob Hansen. I'm a land use consultant with a law degree from BYU Law School, and I'm going to be breaking down the difference between administrative and legislative decisions for members of local municipalities, whether you're a private citizen or developer, or whether you're working for the city or an elected official. This is especially important for planning commission members or city councilors because they often wear multiple hats, and sometimes they might be making an administrative decision, whereas other times they might be making a legislative decision. This is also very important for local developers or private citizens who want to do something with their land, because when they go to the city, they have to apply typically for the city to do something, and it's important to know whether you're asking the city to do something legislative or administrative, because that will affect your rights and even your ability to participate in the public process and what your role is as a member of the public. All right, let's turn first to legislative land use decisions. So these are big picture decisions that shape the community. Think the legislative branch in any other body of government. It's passing new laws. Now, final legislative decisions are always made by the city council, though the planning commission does have a role in reviewing and making recommendations to the city council about land use issues here in Utah. And as long as the city follows the correct procedure, like public notice and the city council having a quorum, then generally these legislative decisions are upheld as valid by the courts. Examples of legislative decisions include enacting or amending zoning laws, including requests for rezoning a parcel. Well, these ordinances can affect a lot of things. Land use is probably the biggest one, but that also includes nuisance regulations, animal control regulations, or even setting the speed limit in your town. The city council, as the legislative body, could also act as the legislative body by imposing taxes or development fees. They are acting as a legislative body when they set the budget for the year, when they create a general plan, or when they negotiate development agreements or offer incentives for developers. Administrative decisions, on the other hand, are typically done not by the city council, but by members of the city staff, though the council can also do some of them. So an administrative decision is really all about enforcing the legislative decisions. So you think about the city council as like your legislative branch, and then everything administrative is kind of more executive branch decision making. So typically these decisions are made by the mayor or city staff or the public works director or some other body that the city council has delegated through ordinance or through the structure of how this town is set up to the staff to make those decisions. Good examples of administrative decisions are approving land use applications for pretty much everything except for rezoning. So this is your conditional use permits, your subdivision applications, your business licenses, issuing building permits or certificates of occupancy, enforcing local ordinances and resolutions, running municipal departments and programs, responding to public concerns or emergencies, and keeping or fulfilling records requests by the public. Now, why does this difference matter? It matters because these two types of decisions are treated differently under Utah law. First, local legislative decisions are inherently different than administrative ones because it's about broad policy making. And so, in particular, the role of the public is key. As a democratic society, we want to hear from the public when we're passing new laws, such as when we're updating the zoning map. We want to hear from you about what you want to see in your neighborhood. Although there are some rules about the procedures that city councils need to follow in enacting these local ordinances, for the most part, as long as they follow the procedures like proper public notice and having a quorum of the city council members, then those laws are upheld by the courts and they're valid. On the other hand, administrative decisions can be more tricky because first things first, they have to follow the local ordinances as written. So although the city council can change the local ordinances, the planning commission or the city staff or the mayor who's administering those decisions has to read the local ordinance very carefully and has to do exactly what it says. They can't just throw it out if it doesn't make sense. Also, public clamor is not allowed when you're making an administrative decision. So if you choose to hold a public hearing when you're reviewing a subdivision application or a conditional use permit application, then as the city you have to be very careful because the public could bring facts to your attention that are relevant to the application, such as saying, oh, there's like a bunch of stormwater, a bunch of flooding in this area, or we have this geological hazard. That's okay. But the public can't show up to the meeting and say, we don't want this kind of development in our town. That's a discussion for the legislative branch, for the legislative decisions. And by the time you get to an administrative decision on a permit or an application, it's way too late for those. So you got to be careful as the local governing body about siphoning out those two forms of public comment and only applying the facts. When you're making an administrative decision, and this is also important for developers because you can rely on this, the city is supposed to ask itself, what are the local rules and am I following it? And that's it. Now, the dual role of the Planning Commission and City Council, this is key. And if you're working especially for a small town, you know that these people wear lots of hats, because sometimes they just don't have the staff to man everything. So the city council obviously does legislative decisions when it passes ordinances, but it can also do administrative decisions when it rules on, say, a conditional use permit application. And so it has to always be thinking to itself, what hat am I wearing? Is this an ordinance or is this an administrative permit that I need to follow my own ordinances for? Another example is the Planning Commission. So the Planning Commission has a small legislative role in recommending changes to the zoning map and the general plan and land use ordinances. So the Planning Commission holds a hearing and then makes a recommendation to the City Council for those issues. And in doing that, it's operating in a legislative capacity. But pretty much everything else the Planning Commission does is really administrative, especially if the City Council has designated the Planning Commission as the land use authority. So again, ask yourself, what hat am I wearing? If you're a city staff member, don't even worry about it. You're always making administrative decisions. So remember, follow the local ordinances and be very fair, and don't try to muddy the water because of the public's opinion about what you're doing. Okay, this difference can be very confusing, and if you're confused, that's fine. And if you are considering an application and you're still not sure, you're not alone. Down in Springdale, Utah, just 2 years ago, there was a case where a developer submitted an application to the town to change the zoning of a parcel, and there was a bunch of things that went on, but the moral of the story is that the town denied it, and it got appealed to the court. And the district court actually said it was an administrative decision, which was wrong. So the Utah Court of Appeals, after the district court made its ruling, reversed the district court and said, no, you got it all wrong. A rezoning isn't actually an administrative decision, it's a legislative decision. And that changed because of the other things going on in the case that changed the outcome. So again, if you feel like you're still a little confused, or you got to review this video every time an application comes in, you're in good hands, because even a judge got it wrong. Okay, so some best practices for cities and for developers. If you're a city staff member, you're only doing administrative tasks, so don't try to legislate from your position. If you're on the city council or the planning commission, ask yourself, what hat am I wearing? And if you're an applicant, just use this rule of thumb. Are you asking the city to apply the rules already on the books, already in its zoning code? If so, then you're asking for an administrative decision. If you're asking the city to step outside of its current rules, change the zoning, change the rules, give you a development agreement, then you're venturing into the legislative territory, and you have a lot fewer guarantees of approval. And if you think someone has made a mistake, then go ahead and contact the Utah Property Rights Ombudsman. They actually provide formal opinions about these sorts of disputes and might save you and everyone else a trip to court. And speaking of the Utah Land Use Ombudsman, they also administer the Land Use Training Fund, which collects money from building permits in Utah and then funds the creation of educational content for local government officials and for private citizens. And they actually sponsored this video, so give them a shout out and thank you for watching.